Hello everyone, I'm Kate Rode from Kingsley Napley, and I have the pleasure of kicking off this session provocatively titled, that was intentional. So what you have here is a trio of lawyers, John Harding and Adam Chapman, more of them later. We also have colleagues dotted about the room who hopefully will be able to participate in the debate that ensues, and we're keen to have that. So let's start. I want to actually start with you. The question I ask myself is, what's the point of medics? And the simple answer is to heal. And therefore, the point of medical leaders and managers is to deliver a system that heals.
Could you speak up a little bit, please?
Yes, I'll try to. Yeah. Lawyers taking the same simplistic... Okay, start again. So the point of medics is to heal. The point of lawyers, at its most simplistic, is to oil the wheels of justice. But as soon as I make these statements, what we all recognise is how very simplistic they are. What does healing really mean? Prevention, cure, prolongation of life at all costs. In the same way, what's justice? Is it accountability? Is it having questions answered? Compensation, retribution, etc., etc. And when I was thinking about it, the most helpful point of lawyers that I could come up with was to prevent the negative effect of lawlessness. Sounds a bit vague. What does it mean? Lawlessness is synonymous with chaotic systems, maverick behaviour and danger. What lawyers are interested in is safety, order, proper process and accountability. Which brings me to the point of us being here. Various lawyers in our healthcare standards team see healthcare through different lenses. I'm a clinical negligence lawyer. I always act for the patients. And I see damaged, usually upset, and sometimes angry people when they have a particular issue with the care that has been provided to them or a member of their family. I see the individual patient's perspective and I hear the patient's stories. I sometimes joke that I'm the dustman, and what I mean by that is we come in and clean up, if you like, in the aftermath of something going wrong. John, a regulatory lawyer, his team sees the story from the point of view of the profession and the regulatory bodies. And then we get to Adam, whose team is a public law team, and they come in the wake of a public scandal, the obvious example being mid-staffs. So we're here because we hope our insights can add to the debate that really are at the core of this conference. We're also very keen to challenge any preconceptions that lawyers' involvement in cases causes delay, stalls good management, and gets under the feet of leaders. What we see very much played out in the public arena at the moment in the press is a renegotiation of the relationship between the public and the NHS. And we really feel that we want to help with that dialogue. We want to reassure you that we're just a necessary part of the system, and the public that we say it serves the same people that the NHS serves, we just have different roles to play. So we would say lawyers have a part to play in the process of delivering a high quality, accountable and transparent healthcare system. We're each going to explain very briefly what we do, think about whether good leadership and management can influence legal outcomes, and hopefully give you some interesting insights along the way. So, as I've said, I'm a clinical negligence lawyer, claimant clinical negligence lawyer, the patient's representative, if you like. And it's very, very important that when I start, you know what I'm talking about. I am not talking about criminal law. I'm talking about civil law. And I'm also very keen to bust a few myths because, for example, in the Health Services Journal, Lord Saatchi, I don't know, you won't be able to see at the back, but "The law is killing patients." That's the headline. Well, the simple answer is clearly we're not. But when Lord Saatchi, in the body of the article, says, under the current law, any deviation by a doctor from standard procedure is likely to result in a verdict of guilt for medical negligence, it's just wrong, and I want to talk to you about that. First of all, most medics in this country are absolutely first rate. We have no difficulty with that at all. A tiny percentage of cases go wrong. Of those, a tiny fraction result in clinical negligence claims. And according to the National Health Services Litigation Authority statistics, in the last 10 years, only around 2% of all of the litigated claims actually go to trial. And some of these would have had to go to court in any event because they will be approving a settlement for a minor or a person under a disability. So the actual percentage is probably slightly smaller. So if we go back to Saatchi's quote, it is actually highly unlikely that any deviation from standard procedure will go to court. And the next thing that I have issue with is the language. It's all wrong. Verdict is what a criminal jury delivers in a criminal trial. Civil law is not heard before a jury, it's heard before a single judge. And then there's the word guilt for medical negligence. Again, a word absolutely laden with blame and culpability that's synonymous with a criminal burden of proof. And that's just not what happens in a civil case. In a civil case, a judge will hand down of a judgment deciding for one party or another. It's very understated. So why is this language being used? I think it's partly to do with the fact that it's more attractive to have headline-grabbing extremes. I also think that there may be a political end in muddying the waters. But I really want to tackle this language because I think it creates a problem. It engenders fear. It permits medics to believe that a claim in negligence is a career-ending event, and it just isn't. It creates fear that any involvement with the law will be a public and intensely personalised attack. And again, that should not be the case. And in the context of a civil claim, that is not the reality. I know this because I have to manage my clients' expectations, and they expect a jury because they've read the press too, and they expect their day in court, and I have to say to them it's actually highly unlikely that they will go to court. So going back to the NHSLA statistics, in the last 10 years, 17% of the cases are ongoing, so we don't know what the outcome is for those, but around 33% were abandoned by claimants, so that's the patients. Over 47% were settled out of court. So what that means is that there was no court appearance made. And then you get the about 2% that we've talked about that do actually have a court appearance. So you can see the reality is going to court is very rare. Another reality is that my team spends a lot of time listening to people and then turning them away. Sometimes we direct them through the complaints procedures. Sometimes we simply advise them that there's no case. Sometimes we send them on and say another solicitor may be able to help you. But the reality is that 10% of the calls that we receive actually become formally investigated claims, and of those, not all will then proceed. So when a case comes to us, what are we looking for? What are we trying to see to establish whether or not there is a claim in negligence? First of all, we look at the standard of care. What we need to see is that the standard of care that was provided was below the prevailing standard at the time. And this is a standard that is judged by doctors, not by lawyers. We call upon medical experts to help us look at what the standard of care should have been. And again, if you're looking at a GDH, you're going to be applying a different standard of care to a tertiary referral centre. So it's once we've established that we think there probably is a want in the standard of care, we then move on to look at how the outcome has been altered by that breach in the standard of care. This is the legal concept of causation. The absolutely barn door event of a wrong limb amputation, you'd have no difficulty establishing causation. Clearly the patient is worse off, that's easy. But the subtler and harder cases would be, for example, the breast cancer case, where there's a 4-month delay in referral for a breast lump. And then we call upon our experts to help tease out what, if anything, has altered the prognosis for that patient. And so causation is often the hardest part of clinical negligence cases. Then after that we move on to quantification, and again there's a lot of preconceptions about this. People see these huge awards and think that they're sort of lottery wins. The reality is that general damages, which is the award that you get for pain, suffering and loss of amenity, if you like the bad luck award that it's happened to you, is quite small. The highest award is around £250,000 for total paralysis with awareness. So you can see that when you look at the multi-million pounds award, that is actually calculated by reference to what's called special damages and future loss. So that is the actual care needs of that particular individual client. So it'll be accommodation, it'll be care, it'll be physiotherapy, etc. So that's a very brief summary of what clinical negligence law does. Does medical leadership influence the process, and can it lead to a better outcome? Absolutely, definitively yes. Well-run units have effective staff, good systems, training to ensure that medical records keeping is given absolute priority, and that the quality of the notes is good. It's extremely difficult to criticise if a case note shows a clear plan and the weighing of risks. The other thing that's been very helpful, and we're seeing more and more, is serious untoward incident reporting. That's very helpful. It speeds up the process, it saves legal fees because people already know what the issues are in the case. Increasingly, we hear of fearless conversations with patients. We've had a number of clients come to us because their consultant has said, I think you need to see a lawyer. And I think that that's a very courageous act. And I would also like to see organisational shifts to encourage this to happen more in appropriate cases. And sort of in parenthesis, I wonder whether actually a clinician who's grappling and reeling with a devastating outcome would also possibly find that helpful, and we can discuss that. Therefore, unsurprisingly, I believe that the debate at the moment about the duty of candour is a very important one. Patients want to be informed, but my sense is also that medics want to help. And I hope that this conference will look at how those channels of communication can be opened for the benefit of the public and the medics. I'd also encourage medical leaders to listen to reports of near misses, look at the patterns. Do they relate to failures in systems? Are they about shortcomings in training? Or is it the attitude of a cohort of staff? And once those issues have been identified, they need to be fearlessly tackled. By creating an open and transparent approach to mishap with a high level of patient participation, leaders can deliver something that almost without exception our clients want, that no other person or family will have to go through what they have gone through. And it really pains me that that is not something that I can deliver for the clients. And that is one of the reasons that I'm personally here, because I would like to be able to deliver that assurance. So just before I hand over to John, I want to read 2 very short quotes because I think it's important to actually acknowledge that there's a huge challenge here. First of all, I'm sure lots of you know it, Atul Gawande, a US doctor, a brilliant writer, in his book Complications, he wrote, "The thing that still startles me is how fundamentally human an endeavour medicine is." And I would absolutely agree with that statement. And I would say that human interactions and relationships are therefore the key to improving culture. And then there's a very extraordinary anonymous piece by a junior doctor from The Guardian's What I'm Really Thinking column. It reads, "I feel as if I'm in the middle of a brutal initiation rite, but of course I can't let my patients see that." The piece continues, "So I'm thinking, am I really up to this? Hello, is there anyone around who can help me?" And I say the challenge for medical leaders and managers is to remove the sense of isolation and fear of mistake from this young doctor, to create a culture where it's permissible to be fallible, provided mistakes are swiftly acknowledged and learned from. And I believe, obviously, that lawyers have a role to play in creating and maintaining that culture. So over to John.
Thanks, Kate. I'm the practice area leader for the Professional Discipline and Regulatory Department at Kingsley Napley. And I want to just pick up on something very briefly that Kate's referred to towards the end, and that's the issue of candor. It's otherwise described in my field as insight. And what I want to touch on is whether the regulatory processes which some of us are familiar encourage insight, candor. And I'll do it by putting it in the context of the work we undertake in the health sector, and that's on behalf of my firm's main client, the Health and Care Professions Council. Some of you will be familiar with that organisation. It's an organisation that has a large number of professions under one umbrella, 15. In recent times, it's added social workers to it, but covers such professions like physiotherapists, dietitians, radiographers, and the like. Does the regulatory process encourage insight or candor from registrants who are being investigated? My view is that yes, it does. That's certainly my experience. Let me just put my view in context by just describing to you very briefly the process of the HCPC in exercising its fitness to practice processes. Let me state at the outset that the purpose of fitness to practice process is not to punish a registrant who's made a mistake, who's had a bad day at the office, or who has been found to be, in someone's view, clinically incompetent. The primary purpose is to protect the public. The public is protected by the HCPC and other regulators, which you'll be familiar, through its statutory committees, an investigating committee which decides whether there's a prima facie case. If there is, it is then passed on to a health or conduct committee. And what is the allegation they are looking at? We've moved away from serious professional misconduct some time ago, and we're now in the world of fitness to practice being impaired. Impairment of fitness to practice by reason of misconduct, lack of competence, because you have a conviction or a criminal caution, or for health reasons. The process to hearing is and has to be a transparent process with full disclosure both at the investigating committee stages and at the final hearing. We are, in order to comply with that full disclosure and transparency, we are reliant on complainants, whether that be a large trust or a member of the public or a patient, to cooperate with the regulator to provide that full disclosure and all the information documents we need. So we come back to, can the process encourage candor and insight? In my view, yes, it can. The reason why is in a number of reasons. My experience is that a registrant who shows insight and deals with the issue prior to the hearing are more often than not allowed to continue to practice. The important point to remember here is that the question that the panel is asking itself, often some months after the event in question or events in question, is whether at the date of that hearing is fitness to practice impaired. A registrant who shows insight and deals with the issues on the day in question, that bad day at the office, we all have them, has gone on courses to address their shortcomings, can come to a hearing and say, yes, I had this problem, but now this is what I've done. My fitness to practice is not now impaired. By showing that insight, as I said, my experience is that registrants continue to practice, sometimes with conditions, often not without. And I come back to what I said at the outset. If you show insight, you will practice, you will continue to practice, because the primary purpose of fitness to practice processes, whether you're at the HCPC or the GMC or the General Dental Council or the other health regulators, 9 in total, the primary purpose is not to punish the registrant, but to protect the public. I've cut my time down a little bit because I'm anxious that there may be some questions and we have to finish at 10. I'll now hand over to Adam.
Thank you, John. I won't detain you too long, but I have a slightly different perspective from John and Kate. As Kate said when she introduced us, I practice in an area called public law, and that's much more, in general terms, about institutions than individuals. It's more about processes and systems as opposed to outcomes, at least in theory, and it's not just relevant to the healthcare field. And I want to touch upon 2 areas. First of all, is something called judicial review. It's something you probably have a vague awareness of. And what it is simply a particular court process which involves the court applying a special set of laws and rules that have been developed to determine how public bodies should make decisions. And in essence, what the court has to look at is whether the decision is lawful. That's to say, does the body have power to make it? Is there a statute or a piece of secondary legislation that you can point to show, yes, we can do this? The decision has to be made in a procedurally fair fashion, and unhelpfully, what's fair depends on the context, so there's no particular guidelines I can give you now. The decision has to be rational, and what that means is that often, particularly when you're taking a difficult decision, there are a range of rational outcomes. There's not one single answer to the problem. It's not like a diagnosis that you experience. There are a range of rational outcomes. You have to fall within that range, and it's only if you fall outside that that your decision is unlawful. And then finally now, if the decision involves an individual, it has to respect their human rights. Now, to put that in practical context, just 2 examples. One thing I'm doing at the moment, I'm working with somebody who is having to make an application to his local CCG under their exceptional funding procedure, which is to say the drug that is best for him is very expensive. It's not generally available under that CCG, so his clinician, his consultant, has to put in an application saying why it should exceptionally be made available to him, and in brackets, so that the money that will be spent on that drug can't be spent on someone else. It's a very difficult decision for the CCG to make. And our role there is twofold. First of all, it's to look at the CCG's policy to see whether that's lawful. We then have a minor role in assisting him and the consultant as to what the policy means and how they might provide evidence to show that it's satisfied. And then after the decision has been made, which I fear will be that he won't get his drugs, assess whether the process that's been adopted has been lawful and followed the policy. So that's one example. Another example that I suspect some of you either have or will have experience of soon arises in relation to service reconfiguration. Whenever somebody wants to move a set of services from one hospital to another to achieve greater efficiencies, greater specialisation, whatever it might be, almost inevitably somebody challenges it by way of judicial review on the grounds normally that a fair procedure hasn't been followed, that there hasn't been adequate consultation either of the patients involved who now have to travel further, of the staff involved, whoever it might be. So there's just 2 practical examples, and that does beg the question, well, what's the point of doing that? What's the point of having a special set of rules to allow those sorts of challenges? And I think there are 3 or 4. The most fundamental is to address the power imbalance that exists between the state, and for these purposes NHS institutions are the state, as against the citizen. That's at the core of it. In theory, I'm not sure how you measure this. It should lead, the theory is, to us being better governed, to better decisions being made. That's the theory. I worked for much of my career inside central government, and I'm not absolutely convinced that it leads to better decisions being made. And then thirdly, the theory is that it allows people to be better engaged, citizens to be better engaged in the process. So to the extent the lawyers facilitate that, that's part of our point. The second area I wanted to touch on that we practice in is in relation to public inquiries, and in particular because during the course of it I was acting for two of the patients groups who were participating in the mid-staffs inquiry. Public inquiries happen typically when there is some issue of serious general public concern. They tend to be very expensive. The direct running costs of the mid-staffs inquiry were around £13 million. And their aims are twofold, generally. First of all, there is a fact-finding process. What went wrong? What happened? Secondly, and sometimes much more difficult, there is a solution-finding process. And there's certainly a major current controversy in the slightly nerdish public inquiries world that I inhabit as to whether lawyers are any good at that second stage. We like to think, we're quite confident that we're quite good at finding out facts, going through evidence. How good we are at helping other professions find their solutions is another matter altogether. And certainly Robert Francis in his inquiry was acutely sensitive to that, and he sought to have available to him a hugely wide range of evidence from doctors, nurses, medical policy experts and so on. But in the end, the recommendations that he made, nearly 260 or so, were his alone. The actual process of a public inquiry is quite straightforward. It's about collecting in evidence, and that's documents. You work in the NHS, you will know the number of documents that are generated left, right and centre. Reams of them came in. Written statements from people and then oral evidence. And you go through that process, you have all these hearings, and what's the legal consequence at the end of it? Actually, curiously, there's no legal consequence. The inquiry chairman has to produce a report, and after that, what happens, happens. There's no particular legal process, whether or not the recommendations are adopted, and you're seeing this, you know, in super headlights at the moment in relation to the Leveson inquiry. Whether any recommendations are adopted is really down to, with a small p, the political process. In relation to mid-staffs, and quite briefly, there were two things that particularly struck me, both during and after the event. I mean, the focus afterwards was inevitably on the examples of appalling care that patients had experienced, on the failings of the trust board, and on the failings of a number of individuals who've been responsible for providing care. But two things, as I say, particularly struck me. There only ever was an inquiry. The only reason why there was an inquiry was because a small group of patients and relatives, and in particular, a hugely and very remarkable woman called Julie Bailey, whose mother had experienced appalling care at mid-staffs, pressurised and pressurised and pressurised. And if we go back to the question, what's the point of lawyers? And one of the point of lawyers, as I've described before, is about holding the state to account. We completely failed. That wasn't unique to us. Doctors failed, the regulators failed, the CMC failed, Monitor failed, the DOH failed. But that was a clear failure, and certainly a lesson for lawyers from mid-staffs, not highlighted, is to think about, well, how in our areas of responsibility we'll let that happen. The second thing I was very struck by at the beginning of mid-staffs, all the way through and at the end, arose from something pointed out by counsel to the inquiry when he opened it. He made a speech setting out what they were going to look at. And one of the things he sought to highlight, was the fact that many of the things that at that stage he anticipated that was going to be found had gone wrong or would need improvement, were things that had been highlighted in the report from the Bristol Hospital's public inquiry about 10 years earlier, which had looked at why cardiac treatment of babies at the Bristol hospitals had gone so wrong. And again, that really begs a question for lawyers who are involved in inquiries. If you found the solutions 10 years ago, why are the same things happening all over again? And there's a lot of sort of navel-gazing going on amongst lawyers in this area as to what we need to do better to make sure that lessons are actually learnt. In summary, sort of findings amid staffs can come under 6 areas. The need for a focus on fundamental standards, the need for openness, transparency and candor, the need for compassionate, caring, committed nursing, the use of accurate and relevant information, and then a strong and patient-centred healthcare leadership. Underneath all that, how do you achieve all of that? I think the common agreement is that there needs to be some form of cultural change, which is particularly where you, I think, as medical leaders, come in. And there was a very good paper published by the King's Fund earlier this year called Patient-Centred Leadership, Rediscovering Our Purpose, which looked at what actually needs to be done. And of course there's a lot, but I thought they encapsulated it very well by saying that it's mainly, for leaders, it's mainly about creating the systems, I would say culture, in which staff are supported to do the right thing. It's clear, I mean our experience collectively for sure is that staff within the NHS, medical staff, do want to do the right thing. The challenge, the difficulty, is enabling them consistently, hopefully always to do that. And I hope I've explained it in some small way, the point of lawyers in trying to achieve that. Thank you.